Good morning. We are on the record, Your Honor.
Thank you very much. Are counsel ready to go forward?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Welcome to the Supreme Court. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Justice McDonald will be our timekeeper. Can everyone see him?
Yes.
Thank you. He'll give you notices of 5 minutes, 3 minutes, 1 minute, and time is up. If the appellant is ready to proceed, please identify yourself for the record and let us know how much time you wish to reserve for rebuttal.
Good morning, Your Honors. May it please the court, Jennifer Smith from the Smith Law Office on behalf of QUAVON TORRES, the defendant appellant. I would like to reserve 8 minutes for rebuttal, please.
Thank you, counsel. You have your 8 minutes.
Thank you. This court should reverse the defendant's convictions for several reasons. The first reason is that the trial court violated the defendant's constitutional rights to confrontation and to present a defense by excluding evidence that Tasia Milton was assaulted 2 days after Freddie Pickett threatened to assault her regarding her testimony at the defendant's first trial. This evidence was important to the defense for 3 reasons. First, it bolstered the defendant's third-party culpability claim against Pickett because it showed that Pickett went to great lengths to intimidate a witness, and the jury could have reasonably concluded that he wanted to prevent Milton from implicating him because he was the shooter. Second, yes.
How does the court even know that that actually happened?
Milton testified at the proffer that 2 days after Pickett threatened to assault her in relation to her testimony, that Pickett's sister assaulted her.
Understood. But how does the court, how does the fact finder know that that actually happened before you allow it in as evidence?
The court believed that the threat certainly occurred. The trial court also appeared to believe that the assault did occur. However, the court concluded, and our position is that it was erroneous, but that the court concluded that there was a speculative connection between Pickett and Milton's assault. But contrary to the trial court's conclusion, the connection here was not speculative. So Pickett threatened to assault Milton in relation to her testimony, and just 2 days later, Milton is attacked and beaten up by Pickett's sister. The obvious implication here is that Pickett orchestrated the attack and sent his sister to attack Milton because of her testimony. So Milton testified that she did not know.
Counsel, could you slow down for a little bit for me, please? I'm sorry that I'm sort of sticking with this, but I'm still trying to figure out how does the trial court made an evaluation of those facts, right?
Yes.
You have a different conclusion for those facts.
Yes.
So what do we do with that?
So our position is that the connection between Pickett and Milton's assault is not speculative, and there was ample evidence for the trial court to conclude that Pickett authorized and orchestrated this attack. And there's case law cited, I believe, between pages 2 and 4 of my reply brief that show that circumstantial evidence is enough here, and that there are cases where a defendant threatens a witness. So they're similar to this situation where our courts found that even if the defendant is not present at the scene and not personally threatening the witness, that even if a defendant's relative threatens a witness, that is sufficient to draw the connection here. And in those cases, the defendant didn't have to be present, but as long as someone was affiliated with the defendant, or especially if it was a defendant's relative, then the courts have found that there was a connection there.
Okay, thank you. Justice Story.
Thanks, Chief. Good morning, Attorney Smith. Could you just make clear for me, because it was a little confusing, not you weren't confusing, but the whole situation was confusing with the multiple trials and all. What is the state of the record as to what Milton was going to say or did say at the second trial about Pickett having the gun before and after, and including what she testified at the trial or what came in through Whalen?
So at the second trial, Milton testified that prior to the shooting, she saw Pickett with a gun, and she identified that gun as the gun that was the murder weapon. Her description was consistent with that being the murder weapon. And following the shooting, Milton testified that she was out on her front porch and that she saw the three boys running back towards her house, and she saw Pickett toss a gun into her yard. She saw Lloyd pick up the gun, and then Lloyd and the defendant and Milton all ran inside into her house.
Okay, so that all came in at the second trial. What did the defendant not get by way of, that point for third-party culpability? Putting aside the consciousness of guilt about whether Pickett tried to, put a beating on her, she did get that out, right?
No, so there was no evidence that Milton was assaulted. The evidence that was admitted by the trial court was that Pickett threatened to assault Milton several days before her testimony in relation to her testimony.
No, I get that, but she did testify. She did get out what the defendant wanted as far as not Pickett's beating issue, but that Pickett had the gun before and after. That did come in at the second trial?
Did, yes.
And it came, and then so what did the defendant need to use Whalen evidence for, or did this defendant, or was that through the state?
So it was the state that admitted the Whalen statement.
Okay, and my last question is, did Judge Fisher didn't disbelieve that this beating happened, right? It was that she was beat up. I mean, it was 5 years later, she didn't still have the black eye, but he didn't discredit that she actually was beaten up. It was just he couldn't attribute it to, he wouldn't attribute it to anything particular.
That's correct. That's correct.
Okay.
And there also was evidence that Milton showed up at a black eye at the first criminal trial as well. So there wasn't any dispute that the assault did happen. The trial court's issue was whether there was a connection between the assault and Pickett. It is not clear beyond a reasonable doubt here that the jury would have rendered a guilty verdict if Milton's assault had been admitted. Evidence of Milton's assault bolstered this third-party culpability claim, and the jury would have been able to see the efforts that Pickett took not to have Milton testify. Milton's testimony was extremely incriminating to Pickett. She put him with a gun before and after the shooting. And Milton's assault would have been extremely important for the jury to hear, especially given the weaknesses and the numerous inconsistencies in the state's case. The third-party culpability claim rested entirely on Milton's testimony, and Milton's testimony was the basis for the trial court's decision to give a third-party culpability instruction. Evidence that Milton was assaulted was powerful evidence that reasonably explained why Milton did not previously implicate Pickett, because she was terrified of him. Evidence of Pickett's threat by itself simply just was not enough to convince the jury to credit her testimony that she didn't implicate Pickett because she was afraid of him. Even if there was no connection between Pickett and the assault, this court has previously found that there doesn't need to be a connection in order for this evidence to be admissible to explain a witness's prior inconsistent testimony. And that's set forth in my briefs in the case of State versus Walker. So even assuming arguendo that there was no connection between Pickett and the assault, evidence of the assault nonetheless would have been admissible to rehabilitate Milton's credibility, to explain why she didn't previously implicate Pickett at the defendant's first criminal trial.
Counsel, there are some questions. Justice Ecker, then Justice Kahn.
I'm fine, Chief. Counsel went on and I'm fine. So I'll take my hand down. Thank you.
Thank you, Justice Ecker. Justice Kahn.
Thank you, Chief. Counsel, I understand your argument, and I get it, that the evidence of the assault would corroborate the threat that was previously made by Pickett. But the judge allowed her to testify about the threat, and she didn't deny the threat, correct?
Correct.
So the defense was free to argue that she shaped her testimony because she was fearful of Paquette. And it seems to me a direct threat by Paquette would be much more powerful than the fact that she's subsequently assaulted. It could have been the assault was from both of them, you know, from being a snitch. She's accused of being a snitch, even as to your client. So I'm trying to understand where the prejudice comes from. I get that it corroborates, but did she need to be rehabilitated when she in fact admitted she was threatened by Paquette? And I'm assuming she admitted she was fearful of Paquette.
She did testify that she was afraid after Pickett's threat, but I think that evidence that Milton was assaulted was far more powerful than just a mere threat.
So if the court had let in the assault and not the threat from Paquette, would your position be that should have been what the court did? I mean, I know your position is both should have come in, but
my position is that both should have come in.
But if the court had let in the assault, wouldn't your argument have been, well, there was no connection here. The direct threat is what the jury should have heard.
Sorry, can you repeat that, Your Honor?
Yes. So a hypothetical. Let's say the court let in the assault, but not the threat from Pickett. Wouldn't your argument have been, hey, the threat from Pickett was, I mean, that's the real fear. She's fearful of Pickett, and he's the one that we argue is the shooter, and that's the evidence that should have come in, because that's the more powerful evidence of her motivation to testify falsely.
I think that the assault is more powerful than threat. I think that a jury would be inclined to not find that a threat maybe would rise to the level of her not implicating him, whereas an assault, she shows up at the first trial with a black eye and she doesn't implicate him. I think the assault is far more powerful for why Milton was silent in terms of implicating him.
So the answer to my question is, if it had been the other way, you wouldn't have argued that the evidence of the threat directly by Paquette, the third party person who's culpable, would have been more powerful. Is that what you're saying? That you wouldn't have been before this court arguing, hey, the court didn't let in the direct threat?
I think that they both should have come in, but I think ultimately that the assault was the most impactful. I'm not sure if we would have been arguing for the threat to come in if the evidence of the assault had come in, but the trial court did admit the assault, or the trial court did admit the threat, but the assault was a necessary follow-up to this threat. So Pickett threatened to assault Milton, and then 2 days later, Milton is assaulted. So I think there's a logical nexus between the two of them, and I think both of them substantiate the other.
No, and I get your argument on that. I was looking more at the other end, on the prejudice end, you know, because my concern is, did she really need to be rehabilitated, or was that just, you know, she didn't fight that issue, that she's scared of Paquette, that he threatened her? If she didn't fight it, you know, do you know what I get your argument that the connection is there, that the jury could be asked to infer that that the subsequent assault was a follow-up on the threat, but I'm wondering, you know, if your point that, did the jury get it just with the direct threat, or did she really need to be rehabilitated on that point?
I think she did. So the state had also went to great lengths to impeach Milton, not only with her Wayland statement, but they had requested an impeachment by omission instruction. During closing arguments, the state repeatedly argued that Milton was not credible, and specifically advised the jury to consider this impeachment by omission instruction that the trial court was going to give. So Milton's credibility, which the third-party culpability defense was based, really needed to be rehabilitated. So not only should this evidence of assault have come in to rehabilitate her credibility, but also for the third-party culpability claim, which the defense alleged against Pickett.
Thank you, counsel. I'm going to yield back to the chief. Thank you for answering my questions.
Thank you.
Justice Acker.
Thank you, Chief. Yeah, I get your point on there, that the two incidents together combined in force and showed that not only was he capable of the threat, but assuming that it came from him, that the assault was directed by him, that he was going to follow through on it, which bolsters, I guess, the third-party culpability issue, as well as her fear, because she needed to explain why she didn't say this to start out with.
Yes.
And I guess it's interesting case because you guys are on opposite sides of this. Often happens at harmless error, but you're on opposite sides of where you usually are. That is, normally the defendant, at least in an insufficiency type claim, is arguing that things are too speculative and it's too remote and who knows. And the state is saying, hey, that's up to the jury. That's not up to the judge. That's up to the jury. And here you're saying your argument is, that there was enough to connect this up. It was his sister who's doing it. There was no other reason that the state put forward for why they had a beef. So it was the trial court being speculative in a way. The logical conclusion is that this is connected to the sister's brother and the earlier threat. I take it that's your argument?
Yes, Your Honor. That's correct.
And I don't know if it's a worth follow-up question, but I mean, so as far as what's speculative and what sort of goes to the jury, do you have any help for us on that issue? Or are you just arguing it based on the facts of the case?
Based on the facts of this case, I think there certainly was enough to put this issue before the jury. And I think that then it could have become a question for the jury as to maybe whether Pickett orchestrated this or whether potentially Milton's sister was acting on her own initiative. But I think that the facts are very strong here, that a jury could not have concluded that Pickett's sister was acting on her own initiative. So Milton tested.
Well, even if she was, counsel, acting just totally on her own initiative. She liked her brother. She wanted to protect her brother. She didn't like snitches, and she was going after this gal. It still is highly relevant to the level of fear that would explain why she testified differently before, that is in the Wayland statement, than after, right? So whether or not it was orchestrated by him, it could still be relevant. That, I take it, as your position.
Agreed.
Can you explain briefly? The state says, "Oh, this is sort of a smoke," and I don't want to put words in Attorney Feldman's mouth, but sort of this is a smoke screen because the fact is that the first police statement she made, which was before these events, didn't include the Pickett point. Can you? I read your reply brief on that, but could you reply to that?
Yes, Your Honor. So Milton was approximately 17 years old. She testified that she was terrified and that she was high at the time she gave her statement. She had been at the police station at that point for about 5 hours. It was around 3 a.m. And she really didn't independently offer much information outside of the police's questions. So her responses were scattered. There were a lot of gaps there. And Your Honors can see from the video of her Wayland statement, she had a very subdued demeanor. She's quiet. She has her hood pulled over her head. But the police also weren't incredibly thorough in the questions that they asked her. So the police only asked her who came back into the house after the shooting. And so that was just the defendant and Lloyd. But I don't believe that she was asked by the police if she saw Pickett after the shooting or whether she saw Pickett with a gun after the shooting. So I think, her not implicating Pickett can be chalked up to a combination of her being young and terrified and not really wanting to speak to the police, but also a lack of thorough questioning by the police on this issue.
Thank you.
Thank you. I would like to delve into the harmless error analysis. So really the state's case here is very weak. So there's no physical evidence linking the defendant as the shooter. There's no DNA, there's no fingerprints. There's no surveillance footage of the actual shooting. The three eyewitnesses, Hall, Jones, and Padilla, none of them identify the defendant as the shooter in photo arrays, just given hours after the shooting. So the state's case here is based on the unreliable Whalen statements of Pickett and Lloyd. And Pickett and Lloyd had every interest in exculpating themselves and implicating the defendants who was not to be charged with murder. I see it appears as if there's a question.
Justice Connor.
Justice Connor, yeah.
Thank you, Chief. Counsel, the statement you just made, there was no physical evidence in terms of the DNA. I thought there were at least two witnesses, a woman with her son and another witness, that although they didn't identify your client, they identified him by the clothes he was wearing, and they identified his movements, meaning the person behind the driver's seat got out of the car and went around the back of the car and shot at the driver who had gotten out of the car and gone into the passenger back seat and opened that door. So I thought there was at least testimony that identified your client, not by name or identity, but by the clothing and by his movements, and observed him as the shooter. Am I wrong on that? Am I reading the record wrong?
So Teresa Jones, Your Honor, testified that she saw the shooter in a blue shirt, and Pickett had testified that the defendant was wearing a blue shirt. But Jones's testimony was inconsistent with the testimony of the other witness Your Honor was referring to, Ms. Hall. And Ms. Hall testified that the rear driver's side assailant, who the state alleged was the shooter, was wearing a black shirt. So that was inconsistent with Jones's testimony as to the color of the shooter's shirt. And the evidence, in fact, showed that it was Pickett who was wearing a black shirt, not the defendant. So there are inconsistencies here in the color of the shooter's shirt. Also, in addition to,
but I was not wrong that at least one witness identified, two witnesses identified the shooter as being the person that was sitting behind the driver, got out of the car, walked around the back of the car, and shot at the person peering in to the back seat of the passenger, right?
Well, so there was one witness who testified that the rear driver's side assailant, he got out of the vehicle and he and the victim were by the passenger seat where Pickett was, but she testified that she didn't see a gun, that she didn't see anyone with his arm extended, and she ultimately admitted on cross that she did not know who the shooter was.
Right. But that wasn't my question. You did say there was at least one witness that saw the person sitting behind the driver get out, wearing a blue shirt, go around the back of the car, extend his hand, and shoot at the person that was bending down to. I thought the testimony was that he was going to get a bat. He didn't want the guy in the car. He was going to get a bat, but
just the response.
I'll take a closer look, counsel. That's fine. Thank you. Thank you. I yield back to the chief, but I saw your time was up, but I yield.
Thank you, Your Honors.
Thank you, counsel. Your time's up. You may use some of your rebuttal time if you would like.
Briefly, yes, just to respond to Justice Kahn's question, Teresa Jones testified that she saw all four individuals outside the vehicle arguing. She was the one who testified that the shooter wore a blue shirt, but she never testified that the shooter got out of the rear driver's side. Unless Your Honors have any other questions, I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel. I may have a question for you on rebuttal.
Yes.
Attorney Feldman.
May it please the court, my name is Lori Feldman. I'm a Deputy Assistant State's Attorney representing the people of the state of Connecticut in this matter. Your Honors, the trial court did not abuse its discretion by excluding evidence of the alleged altercation occurring prior to the defendant's first trial. And if the court did abuse its discretion, it was an evidentiary error only, and the overwhelming evidence of guilt means that error was harmless. This court's decisions give the defendant a right to introduce evidence of third-party culpability, but only if that evidence directly connects to the third party and to the crime on trial. Deciding whether that connection is direct enough is a matter left to the discretion of the trial court. Likewise, the scope and extent of evidence of threats made to a witness that are offered to explain the witness's prior inconsistent statements is a matter left squarely in the discretion of the trial court. This court's cases do not hold that evidence of threats must be admitted as a matter of law. They give the trial court discretion to determine whether the evidence is sufficiently tied to a third party and to the matter on trial. The defendant presents reasons why the trial court in this case could have exercised its discretion to admit the evidence of the outside altercation and to admit all of the evidence rather than the portion of the evidence that it did admit.
Thank you,
But
Counsel. Counsel, could you just put a marker there, a hold marker there? There are questions by Justice Daria, then Justice Ecker.
Yes.
Thank you. Good morning, Attorney Feldman. Am I right in remembering that the evidence of in the courthouse dispute, okay, Freddie was there, and one of the people with Freddie said something to the effect of, I'm not going to quote this right, you know, you should get your sister to do it. Okay, am I right?
The exact wording was that Freddie said, not, I'm going to send somebody to beat you up, which is what Pickett later testified to in front of the jury. But during the proffer, she said that Pickett said, I'm going to whip your ass. And they kept fighting back and forth with each other. And then the other person said to Pickett, don't argue with this girl. You have a sister named Ash Black. That was it.
Okay. And so, I mean, I guess, you know, as often happens in the law, I suppose, you know, how direct needs to be, how clear needs to be. I mean, it could be clearer, but she was threatened that somebody's going to whip her ass, and 2 days later, it happens, including with the sister there. I mean, temporally, you know, the people that are involved, I think the evidence was that they didn't know one another otherwise. You could correct me if I'm wrong, but, you know, the trial court speculates that, hey, it could have been anything, could have been a dispute about anything. I think the evidence was they didn't know each other about anything else. So, I mean, he's making a third party culpability claim that it was Freddie. That seems pretty direct and helpful. Why am I wrong about that?
For a number of reasons, the state respectfully disagrees in terms of what the proffer actually showed. First, in terms of how clear is clear enough, our case law leaves that question to the trial court as long as reasonable minds can differ. And here are the many reasonable reasons why the trial court could find that this was not clear enough. And we need to look at the proffer, not what she testified to later, not what she testified to in 2014, which was not before the trial court. The trial court exercised its discretion based on the proffer, and the defense had plenty of notice with the state having filed a motion and the trial court saying, I need to hear what she has to say. Plenty of notice to make the proffer. So first, in terms of the threat intimidating her so that in 2014 she didn't testify, she never said that in the proffer. She never said she thought this occurrence had anything to do with her trial testimony. She never said in the proffer that this occurrence scared her and caused her to change her testimony. She testified that this event occurred and never said that she herself thought that it was connected to her trial testimony, let alone that it influenced her trial testimony.
This is a proffer by testimony. It's not a proffer, you know, if I'm making the proffer, I make it pretty specific. She isn't the most cooperative of witnesses because that's the point. The point is she doesn't really want to be testifying to this. So
she was extremely cooperative with the defense, which was presenting the proffer. She wanted to help the defense. This was her beloved cousin, and she was trying to help, and she was never asked during the proffer, how did this influence your testimony? Or what did you think this matter had to do with? She wasn't asked during the proffer. With regard to third-party culpability and trying to tie this incident into Pickett, The only tie-in to Pickett, and to Pickett would have had to instigate this incident for it to show anything about his guilty state of mind, and there is no evidence of that. And in fact, the only evidence that it connected to Pickett was the hearsay she offered of this woman saying, "I'm Pickett's sister." This was hearsay. There was no evidence that Pickett had a sister. And I should add that in 2014, when Milton testified about this incident, she said she didn't know who this woman was.
I mean,
and she never said this woman.
That seems, I mean, it's not like you're going down rabbit holes to ask a lot of collateral questions. I mean, if she didn't have a sister, you ask her that question, that comes out somehow. And that's end of story. And then she's got no credibility. I just look, if you were prosecuting Pickett for this, it's hard for me to imagine that statement doesn't come in, and that you wouldn't rightly get it in. I mean, this is one of those good for the goose, sauce for the gander, or whatever the phrase is. I don't want to use the wrong idiom, but it just seems unimaginable to me that the state wouldn't want that statement in, and by all rights would get it in. Well,
the state would perhaps argue for it, perhaps would present a more full proffer and leave it to the trial court's discretion. This is third-party culpability evidence where there is no evidence that Pickett even knew about this event. And if he did know about it, you had suggested that there is nothing else that it could logically be connected to, and that's the defense position. But bear in mind that according to Milton's testimony and Pickett's testimony, everybody's testimony who was at Milton's house on the day of the crime, Milton and Pickett spent the day together, chilling in her bedroom, getting high together, along with her cousin and Lloyd. They spent the day socializing, getting high, enjoying one another's company. We have no idea what issues there might have been between them.
The state could have asked her when she testified. I mean, that's. I feel like every other case we have with the state, that's the comeback, is that's for the jury to determine. And what's the harm in? Well, let me ask you this question. It's unfair. I don't mean to argue with you. What prejudice was there to the state, other than this shouldn't have come in? I mean, other than you would have had to deal with it. What prejudice is there? This is the third-party culpability defense she's trying to make.
Well, she was able to make her third-party culpability defense. She presented her testimony about what she saw and why she changed her story and so forth. And that's why this is an evidentiary question, not a constitutional one. But in terms of what prejudice, in any case, in all of the cases that I've cited where the defense wants to introduce evidence, or let's take the example you mentioned where the state wants to introduce evidence suggesting that the defendant made a threat that influenced a witness's testimony. It is black letter law that unless the state can directly connect the defendant to that threat, speculations and presumptions do not suffice. And the trial court applied that law here. Again, reasonable minds can differ, but that's where the trial court's discretion comes in. And the trial court decided to admit the evidence where Pickett directly said, "I'm going to whip your ass and you're a snitch." But this murky incident where we don't know what it was about, we don't know if Pickett knew about it, the trial court reasonably concluded that it was too speculative to admit. Partly the trial court has to manage the trial in terms of just how many peripheral issues to get into. And here there was no connection. As I indicated, Milton never said during the proffer that this incident affected her testimony in 2014. And that was supposed to be part of the point of the evidence, and she didn't make that connection.
Thank you. Appreciate it.
Yeah.
Thank you. Justice Acker.
Thank you. Two things. First, on the proffer versus trial testimony point, I didn't read the whole transcript. I mean, I just recall reading this, but I certainly don't have the knowledge you do about the trial. But my recollection is that the offer was renewed at trial, and the defense counsel said, well, the state opened the door, whatever it was, but it was the defendant tried again to get in the assault evidence at trial. And at that point, didn't the judge have the information that you're saying the judge didn't have earlier?
No, the judge did not have all of that information, but the reason that that issue came up is because that was at a certain point in Milton's testimony where she told the jury that Pickett threatened her in the courthouse, and she did not get beat up in the courthouse, but they seen me on the street, and that's when it happened. So actually that adds to the state's point that notwithstanding the trial court's ruling, the jury did hear that she got beat up on the street.
Because we can speculate that that's when it happened means she got beat up, but we can't speculate that when the sister was expressly referenced in a threatening conversation that the sister might have had something to do with her brother's intentions. I mean, let me put it this way, and this is, I guess, good for the goose, good for the gander. My head's spinning, sort of, because of and the truth is, it's not just the state, it's defendants and it's judges. When things are speculative and we prefer them to be speculative, then they're speculative. And when it's a reasonable inference, then it's a reasonable inference. And, who knows what the real rule is. I think it's pretty clear here that it's not speculation connecting it up with Pickett. But, Judge Fisher disagreed. And, do you know the case of State against Noel Bermudez? It was argued in our court in the 6th term.
I don't remember it by name.
It's a case in which it's a delayed. It's all about the credibility of a witness, and the witness came in 12 years later and said it was my ex-husband, and implicated the defendant. And the big question was, why did she come in so late? And the state put in a lot of evidence about how scared she was. There were gang affiliations. She was, quote, relocated out of state. And there it was totally kosher, totally fine. Of course, we put in evidence about how scared she is and all of, the gang affiliation stuff and the fact that she's put out of state by state. But here we don't. And I'm just understanding it may be an unfair question if you don't know the facts of this case, but I was going to ask
Your Honor,
to reconcile the two situation.
I can reconcile them, and that is, it's a matter of trial court discretion. If reasonable minds can differ about where the line is between direct connection, which this court sets a very high bar when it comes to third-party culpability evidence, direct connection and speculation, trial court discretion comes in there.
Does the discretion? I don't recall, but maybe you'll have. Does the discretion ever get exercised, like with the state losing instead of the defendant losing, or is the underlying rule that the state always wins on the discretionary calls?
Are you saying, does this court ever say that a trial court abused its discretion?
No, I'm saying the trial court, sometimes it goes, sometimes it goes in favor of the defendant, sometimes in favor of the state. Because I don't know the answer to that. I have not been a trial judge in the criminal side.
Yes. I'm in the middle of a very long transcript now that at some point you will become familiar with, where many rulings go for the defense and then many for the state. Of course, trial courts exercising their discretion in the moment based on the proffer before them, go both ways. And of course, you almost never see the evidence that the state doesn't get to introduce. And that is a very key point.
I totally get that. I mean, here sort of it looked to me like the trial court split the baby. If you want to look at it from a cynical or rough justice point of view, gave some, but not 100%. Okay,
the trial court did split the baby, but it split the baby between direct evidence and speculative evidence. And it gave its reasons that we know exactly what Pickett said and that he was behind it in the hallway. We don't, in the murky outdoor incident where nothing was said about this trial.
Thank you very much, counsel.
You're welcome. Thank you. Your Honors.
Attorney Feldman, this is a question from Justice Kahn.
Oh, yes.
Thank you.
Thank you, Chief. Counsel, my question is following along the same line, but I'm trying to understand. I get your point that that when looking at whether the trial judge abused his discretion, in not allowing this in. We look at what was proffered. But I thought that at least in the proffer, there was some mention of snitch, being a snitch, and some mention of, or some indication that one of the participants was Pickett's sister. Am I wrong to read that way?
You are right with regard to the evidence that the jury heard. Pickett in the hallway got into a fight with Milton in the courthouse and said, "You're a snitch." They called each other snitches. And the third party said, you don't fight with her. You've got a sister named Ash Black. However, with regard to the outdoor incident, there was no testimony in the proffer about what that concerned. In fact, I think that Milton specifically testified that nobody said it concerned the trial. So it was.
Well, it may not have concerned that trial, this particular defendant's trial, maybe in their mind, but it would have concerned snitching on Pickett, no? And so to Justice Doria's earlier point, it's hard to imagine that on Pickett's trial, the state wouldn't argue, hey, he threatened her, and somebody mentioned his sister, and 2 days later, his sister is involved in an assault on him, on her. Wouldn't that have been the argument by the state?
Well, with regard to Pickett calling her a snitch, this was the only trial that Pickett could have been referring to, so far as we know. But the state might have argued for introduction of the evidence, and I think that the trial court would have been within its discretion to say there is no direct evidence that Pickett even knew about this incident. And with third-party culpability evidence,
but you don't
there
need
needs to be.
Proof. But you don't need to prove that the defendant knew. The jury could draw inferences that if his sister beat her up, she was sent by him, and the state would probably argue that, because you can't, that's within Pickett's control, what he knew. So unless he was there during the assault, so that seems a bit tenuous. But well, let's assume we disagree. You said reasonable minds disagree. Let's assume we disagree and we believe it is an abuse of discretion not to let this in. Can you address the prejudice argument? And specifically, I know you addressed it at the outset of your argument, but I'm interested in your perspective on, did the jury hear enough about the threats from Pickett to support the third-party culpability defense? Because the defense's theory is that it went directly to the third-party culpability. Can you address that aspect of it, whether it was bolstered or rehabilitated the point that Milton was likely to lie because she was afraid of Pickett?
I would be happy to. I just want to answer your earlier point about whether this was connected to Pickett or not. I just want to give a contrasting case to make my point. State versus Taft, where the issue was whether evidence was properly introduced that the night before trial started, two men approached the complaining witness, shoved him against a wall, and said, "We have a message from the defendant. Don't show up tomorrow." The reviewing court held that it was within the trial court's discretion to let that evidence in. "We have a message from the defendant. Don't show up tomorrow." The reviewing court did not hold that evidence had to be admitted as a matter of law. And I simply offer that as a contrast to this case, where there was no message. "We have a message from Pickett. Don't testify at this trial." There was nothing about Pickett sending them or about this trial. But with regard to prejudice...
But isn't that because the message was sent very clearly earlier from Pickett himself? I mean, do they need to say it when he says, I'm going to beat you up?
Well, I think that, yes, if there's some question about whether he has instigated this incident or not. And, they were going back and forth with each other. They were yelling at each other, calling each other a snitch. And he said, "I'm going to whip your ass." And she yelled back at him. There's no necessary connection between the two incidents. But to the extent that the trial court abused its discretion in excluding this evidence, this is evidentiary error. This court's Esposito decision held that exclusion of a direct threat to the defendant there that arguably caused him to change his statements was evidentiary and not constitutional error, because the defendant was permitted to introduce his arguments about how these threats impacted him. And here, the defense was permitted to introduce evidence of third-party culpability. Milton testified about how she claimed now that Pickett dropped the gun at the front of the house and then the other two brought it into the house, and that she saw Pickett with the gun earlier in the day. And she testified that she didn't say that earlier, and she gave an abundant number of reasons why she didn't tell police that and why she didn't testify to it at the earlier trial, including the fact that she was afraid of Pickett because he had threatened her. And she said, she was asked, did they beat you up in the courthouse? And she said, no, but they seen me on the street and that's when it happened. So the jury heard that her many excuses for not giving this account earlier. In addition, she had no credibility, so that even had the jury heard about this, they were not going to believe her account and believe that it proved that the created reasonable doubt. She claimed amnesia about ever having talked to the police. She claimed amnesia about having testified in 2014 at the first trial. This was incredible in and of itself, but especially in tandem with the fact that Lloyd, Pickett, and Amber Torres all got on the stand and said that they didn't remember anything. She claimed that she said in her prior testimony things that she was then given the transcript and they weren't there. She said she didn't tell police things that she had just watched the police statement along with the jury, and the jury heard her say them. She said that the police coerced her during that statement. The jury sat there and watched her police statement with her and saw there was not a hint of coercion. And she did not explain why 2 years before this alleged threatening behavior occurred, when she talked to the police, she told the police that she saw the defendant with a gun in the afternoon, that when the two came back to the house, the defendant and Lloyd, and they came in the house, nobody else came in. Now, it's true that she wasn't asked, did Pickett come back and drop the gun on the lawn? But she said, not the third guy. The two came in the house, not the third guy. She did not say that he dropped a gun on the lawn, and she was she's incriminating her cousin, her beloved cousin, and not mentioning anything at that point about Pickett doing something incriminating. She was shown a photo array where she picked the defendant, her cousin, from the photo array and said he had a gun, and she was shown a photo array with Pickett, and she did not make a definite identification or say anything about Pickett implicating him. So whereas Milton was not a credible witness in this case, the state's evidence was overwhelming. 4 people witnessed this murder. Pickett and Lloyd separately told the police the same account of what led up to it and what transpired in all material ways, which is that the victim got angry when he realized the defendant was in the car. He went to get the bat out of the back passenger seat. The defendant hopped out of the car with his gun and shot the victim, and they all fled. And when they fled, Pickett went off separately, and the defendant and Marcus Lloyd went back to the house where the defendant had his sister hide the gun. Meanwhile, with no knowledge of these police statements by Pickett and Lloyd, Lachelle Hall separately told the police that she saw the person sitting behind the driver, and we know that's the defendant, hop out of the car, get out of the car, and shoot the victim on the passenger side. She saw that the shooter was not Pickett, whom she knew, and was not the man in the red shirt, who we know is Lloyd. And she saw the 3 men run off, Pickett first, and the shooter last. And we can see on the videotapes that the defendant is the last person running. Teresa Jones, unaware of what Pickett, Lloyd, and Hall have told police, said that she saw the incident and saw that the man in the blue shirt was the gunman. And the defendant, we can see on the videos, is the man with the blue shirt. Jones said that the gunman was not Pickett, who she knew. or the man in the red shirt, and that's Lloyd. And she saw them run off. And again, she saw that the shooter was the last man running. And on the videos, that last man is the defendant.
Just a second.
I understand your harmlessness argument, and it's well made in the brief, and you're making a good argument now. I guess the defendant says that, well, Lloyd and Piquet are heavily interested and biased in the case, so let's put them aside. And really, we're talking about, I guess, a combination of Jones and Hall and the videotapes, and at least, Milton selectively. But isn't it true with respect to Jones and Hall that there are elements and aspects of their testimony that were either inconsistent, internally inconsistent, or inconsistent as between the two of them, or inconsistent with some other evidence, so that there is no perfect witness here, and it's really about piecing it all together. And if that's true, then the pieces matter.
Your Honor, Jones and Hall each saw what they saw from different perspectives. So, for example, Hall couldn't see the gunman's arm, but she saw that it was the person who was sitting in the back seat behind the driver who got out of the car, and then the shots occurred and the victim fell dead. Jones clearly saw, with no question in her mind, that the shooter's shirt was blue. Hall said she didn't know what color the shooter's shirt was. So they didn't each fill in every piece, but even in terms of Pickett and Lloyd, interested witnesses, yes, but they were separated from the time of the crime, and they told the police the same account of what occurred in terms of the baseball bat and in terms of the defendant getting out of the car with the gun and shooting the victim.
They lied a lot. They have both lied also quite a bit, so at the beginning, right? I mean, they told different stories. They said that they walked. They didn't tell the story. Piquet told a lie about which way he ran and so forth. This is, again, the transcript better than me, but my understanding, I mean, Piquet was obviously an interested party.
Two independent witnesses said it was not Piquet and it was not the man in the red shirt, who we know is Lloyd. And in addition, it was the defendant who gave his sister the gun and said, "Get rid of this." And the forensic evidence supports the state's theory and cannot explain Pickett, for example, being the gunman. The state's evidence shows that the victim was standing inside the back with the back passenger door open, reaching in to get the bat. The blood splatters are on the inside of the back passenger door. He was shot from behind. There is no blood on the front passenger door. Pickett is sitting in the front passenger seat. So the evidence is really overwhelming. Is there every witness seeing the same thing and testifying identically? No. Evidence together. And there is lots of direct evidence that Pickett was not the gunman, and lots of evidence that makes it overwhelmingly clear that the defendant was.
Counsel, you have less than 1 minute left.
Yes. Your Honors, the defendant has not proved harm if the trial court did abuse its discretion. And I would just like to comment briefly on the prosecutorial impropriety arguments in case counsel wants to address those in her rebuttal. And particularly the statement about the prosecutor saying the three witnesses gave the same account. The three witnesses very clearly testified about different things that they saw from when they started seeing and what they saw. And the jury would have heard this argument the way the prosecutor clearly intended it, which was that these three witnesses' testimony, as I just argued in terms of harmlessness, that these three witnesses' testimony fit together. So the state respectfully requests that this court affirm the defendant's conviction. Thank you.
Thank you, counsel. Attorney Smith.
Thank you, Your Honor. Contrary to the state's assertion, this is a constitutional claim that involves the defendant's right to present a defense and his right to confrontation, and this error is not harmless. The state's case is incredibly weak and is based on these unreliable statements of Lloyd and Pickett, who had every interest in exculpating themselves to avoid a murder charge. By their own admissions, Pickett and Lloyd's statements were riddled with lies, namely about where Pickett ran after the shooting. At the second trial, Pickett admitted that he actually did run down Orchard Street past Milton's house, presumably because surveillance footage showed it. The only reason that Pickett would have to lie about why he ran down Orchard Street was because he had something to hide about what he did there, namely tossing the murder weapon into Milton's yard after the shooting, which gives credence to Milton's account that Pickett was lying about this.
Counsel, there's a question. Justice Doria.
Thanks. It's always vexing to me to figure out the line between evidentiary and constitutional. But I know that, we look at, what arguments did the defendant get to make? And clearly, the defendant didn't get to make everything he wanted, but I'm wondering, give me your view as to why this goes from evidentiary to constitutional and why the case law would support that.
So evidence that Milton was assaulted is very significant for the third-party culpability, because it shows that not only is Pickett threatening Milton, but he's also going to this additional length in enlisting his sister to orchestrate this attack. And so this shows that Pickett is clearly very nervous that Milton is going to implicate him in some way. And she, in fact, did implicate him in a very significant
But that sounds at best to me, but tell me if you know what the case law says, that sounds at best to be, maybe a powerful harm argument. If it's an abuse of discretion, if it is, that maybe that goes to harm. But I don't see it. I don't see why it's constitutional and that the state would have to carry a burden here.
It is because it violated his constitutional right to present a defense. So this evidence went directly to the defendant's third-party culpability claim. And there's also case law indicating that a defendant can also has the right to present a defense even via cross-examination of a state's witness. I believe that's State versus Andrews. But there's also ample case law indicating that a witness's motive for testifying or prior motives for not testifying in a certain way implicate constitutional concerns here. And certainly Milton's impetus not to implicate Pickett at the first trial is very important here. And the jury needed to hear about this assault because this is far more powerful evidence than a mere threat as to why she would not implicate Pickett in the past.
Thanks. All set, Chief.
Thank you, Justice Kahn.
Thank you, Chief. My question, I have two questions. One is, if we adopt your definition of what's constitutional, then anytime a court makes an evidentiary ruling, because your client was allowed to argue third-party culpability, got the instruction, made the argument. Anytime a judge makes a ruling about what comes in or doesn't, then it rises to the level of a constitutional claim. Because you started off saying, well, the right to confrontation, but she was confronted, she was on the stand. Then you said the right to present a defense. So that would basically mean anytime the court rules on an evidentiary claim, it would always rise to a constitutional level.
I don't think that's true, Your Honor. But I think in this specific case, when we have the defense raising this clear third-party culpability defense, and this evidence is in support of that, I think that certainly implicates constitutional concerns here. But I don't think that would translate to every case that there is. But certainly in this case, where the defense is unequivocally third party, and that this evidence really connects to that, I think in this situation it certainly is a constitutional claim.
Let me ask you my second question, counsel, and that is, I heard your opponent say that although the court kept it out, when during questioning, the witness was asked about, was she afraid, and did they beat her up in the courthouse, and to which she responded, no, but they see me on the street, and that is when it happened.
I'm glad you brought that up, Your Honor. I think that her testimony on this point, I think, was very vague, and it was quickly added in at the end. And I'm not sure if the jury understood that she was beaten up, and the trial court didn't allow any further questioning about it, and defense counsel never argued during closing arguments that she was assaulted. But there's a difference between Milton testifying what she did, that they seen me in the street and that's what happened, which is very vague, and that Pickett's sister beat her up and referenced Pickett during the assault 2 days after Pickett threatens to assault her. I think the latter evidence is extremely important to this third-party culpability, and I just don't think that testimony.
So the jury did not. I understand your point. You're saying that she didn't elaborate, and you're not sure if the jury caught it.
Yes.
But it was not struck from testimony. Is that correct?
It's not struck. That's correct.
Okay. And then my other question. So if it was not struck from testimony, wouldn't you want to argue that she herself established the connection? I mean, if she says not there in the courthouse, but they did it later, she identified them as being connected.
I don't think so, Your Honor. I think her testimony was very, very vague, and there was no reference to Pickett's sister being the one who was assaulting her. There was no reference that it just wasn't clear that
maybe my question wasn't clear, counsel. I thought that really supports your argument that the court should have let this in, because if she, the victim of the assault, identified it as being part and parcel of the threat, doesn't that help you make the connection?
Yes, Your Honor.
Okay. All right. Thank you for answering my questions. I yield back to the chief.
You may continue, counsel.
Thank you. Your Honors, ultimately, due to the inconsistent testimony between the three eyewitnesses, Pickett and Lloyd, and their varying statements, we really don't know what exactly happened here at the time of the shooting, because all of their accounts conflicted with one another regarding the position of the shooter, the position of the victim, and the color of the victim's shirt. We have Jones testifying that all four men were outside the car. In his statement, Lloyd initially indicated that all four of them were arguing outside the car, but then he changed his answer to only the defendant and the victim were outside the car. We have Lloyd and Pickett's versions conflicting about where the shooter was. Pickett said that the shooter is by the rear passenger side where Lloyd is, but we have Lloyd saying that the defendant was by the rear driver's side door. So we have them on opposite sides of the car. We have Hall's testimony that they're up by the front passenger seat, which conflicts with Pickett and Lloyd's accounts as well. Ultimately, and as the appellate court previously concluded in reversing the defendant's convictions the first time, that this case is full of substantial this case raises substantial concerns due to the inconsistent statements and contradictory testimony. And largely, the evidence between the first and second criminal trials was the same. And ultimately, this court should conclude that the admission of this improper evidence was not harmless beyond a reasonable doubt. Thank you for your time.
Thank you, counsel. Much appreciated. With that, we will be in recess until tomorrow morning. I will see the justices in the virtual conference room, let's say in 10 minutes. Thank you very much. Everybody stay safe and be well.